The picture a plastic bottle sitting on the shelf of like almost every bathroom cabinet in the world for over a century,
Oh, yeah.
right? A product so gentle, so universally trusted, it literally has the word baby in the name. But now, imagine the absolute whiplash of watching that exact same white powder trigger a staggering $1.5 billion judgment for a single person in one courtroom.
Just massive.
And then just months later, a completely different jury looks at the exact same product, hears the exact same allegations, and completely clears the company of any wrongdoing whatsoever.
Oh, yeah.
That is the reality of the Johnson & Johnson talc litigation right now. It's a legal and scientific earthquake over an item most of us grew up with. If you enjoy content like this, please take a moment to like, subscribe, follow, and turn on notifications so you'll always know when new content is released.
And really quickly before we jump into the sources today, we do have a brief update on the Martin Stevens versus OpenAI situation.
Oh.
Yeah, so there is still no lawsuit filed. The parties are in a voluntary quiet period right now, and no settlement has been confirmed. Also, the dead man's switch has not been activated, and Stevens is confirmed to be safe.
Good to know. Well, welcome to today's deep dive. We are looking at a literal mountain of source material today for you.
Seriously, it's a lot.
Yeah, ranging from legal updates published by law firms actually in the trenches of these trials to medical studies from global health organizations and even corporate litigation analysis.
It's coming from all sides.
Exactly. And the mission today is to figure out how baby powder, it's a simple household staple, spawned over 68,000 lawsuits. We're going to unpack the fiercely divided science surrounding talc and explore the highly controversial legal maneuvers a corporate giant is deploying to just survive a storm of this magnitude.
Right, because the scale of this is just hard to overstate. I mean, we're looking at a scenario where both the legal system and the scientific community are fundamentally struggling to establish a definitive truth. And they're doing it with billions of dollars and, frankly, profound human tragedy just hanging in the balance.
So to really grasp the volatility of this landscape as of, June 2026, we have to look at the mechanics of the legal whiplash I mentioned at the top.
Yeah, let's get into that.
Let's start by looking at December 2025 in Maryland. So a jury hears the case of Cherie Kraft. She developed peritoneal mesothelioma, which is a highly aggressive, fatal cancer affecting the lining of the abdomen.
Just awful.
It really is. And the jury didn't just side with her. They handed down a $1.5 billion verdict.
Insane number.
Right. That breaks down to $59.8 million in compensatory damages and a massive $1 billion in punitive damages against Johnson & Johnson, plus another $500 million against a subsidiary.
Which is, I mean, $1 billion in punitive damages isn't just about making a victim whole.
No, not at all.
That is a jury actively trying to financially cripple a specific corporate behavior.
Yeah, it's like a statement.
It's a profound statement by that jury. Like, in the American legal system, compensatory damages cover the tangible stuff, medical bills, lost wages, the quantifiable cost of suffering. But punitive damages are an entirely different mechanism.
They're a punishment.
Exactly. They're designed to punish and deter. So when a jury slaps a $1 billion penalty on a single plaintiff's case, they're signaling a complete conviction that the company engaged in extreme willful negligence.
Right, because in that Maryland trial, the plaintiff's team successfully convinced those jurors that J&J actually knew about asbestos contamination in their talc supply and actively chose to hide it from consumers.
Yeah.
But, when a number like $1.5 billion hits the news cycle, the public assumption is just that, well, the debate's settled and the company's doomed.
Right, you'd think so.
But the sources show a completely fractured reality. If you fast forward just 6 months to right now, June 2026, in Los Angeles, a different jury hears a consolidated lawsuit filed by the families of 3 women.
Mary Owens, Bonnie Tienken, and Geneva Williams.
Yes, and all 3 women tragically died of ovarian cancer after using talc-based baby powder for decades. So you have the exact same tragic outcome, same product, same underlying allegations of contamination.
But the Los Angeles jury delivers a total defense victory.
A total victory. They found J&J was not negligent in selling its cosmetic talc.
Yeah.
Literally $0 awarded.
It's wild. That contrast really reveals the inherent unpredictability of the jury system. Like, following that Los Angeles verdict, J&J's vice president of litigation, Eric Haas, he publicly framed the Maryland outcome as an extreme outlier.
Of course he did.
Right. He repeatedly dismissed the plaintiff's underlying claims as, quote, junk science. And he argued that the Los Angeles verdict is the one that actually actually aligns with the current scientific consensus.
Because, I mean, the burden of proof in these civil cases rests entirely on the plaintiffs, right?
Exactly. They have to prove by a preponderance of the evidence that this specific bottle of powder caused this specific cancer, sometimes decades later.
Which is so hard to do. And there's this really striking detail in the coverage of the LA trial that kind of illuminates why that burden of proof is so heavy.
Oh, the juror interview.
Yeah. One of the jurors, Henny Marshall, spoke to the press about their deliberations. And she pointed out this massive vulnerability in the plaintiff's case.
Right.
She said that some of the plaintiff's own healthcare experts admitted on the stand that they do not explicitly warn their own patients against using talc.
Which is just a killer for their argument.
It really is. Marshall basically reasoned that if these highly credentialed doctors genuinely believed the cancer link was definitive, their very first action would be advising their own patients to throw the product away.
It makes total sense.
Yeah, the fact that they didn't created this insurmountable cognitive dissonance for the jury. I mean, it's like a high-stakes game of legal roulette. The exact same product yields either a billion-dollar punishment or a total exoneration, depending purely on which courtroom you walk into.
And that juror's comment gets to the heart of how juries process expert testimony. You have this courtroom dynamic where two sets of incredibly credentialed scientists are looking at the exact same data and presenting diametrically opposed conclusions.
Right.
The plaintiffs present internal corporate memos and epidemiological data linking talc to cancer. But then the defense brings in pathologists who testify that there is zero physical evidence of talc or asbestos in the affected tissues.
They point to, what, genetic mutations instead?
Yeah, genetic mutations or other environmental risk factors. The legal system is essentially forcing 12 lay people to act as scientific referees.
Wow.
Yeah, demanding a definitive yes or no verdict on a question that the global scientific community is still fundamentally debating.
And that courtroom chaos exists precisely because the legal system is demanding a black and white answer from a scientific community that is still completely in the gray. To understand why this debate is so intractable, we kind of have to look at the mechanics of where this product actually comes from. Like, does talcum powder cause cancer? The answer starts deep underground.
Right, because talc is a naturally occurring clay mineral. It is mined directly from the earth. And the fundamental vulnerability of talc, and really the genesis of this entire decades-long litigation, is geological.
Because of what it's next to.
Yes. In the earth, talc deposits are frequently co-located with asbestos deposits.
And asbestos is a universally recognized definitive carcinogen.
100%. So the mechanical concern is that during the extraction and milling process, microscopic asbestos fibers inevitably contaminate the talc supply. The entire debate centers on whether it's physically possible to separate the two minerals with enough precision to guarantee a perfectly pure consumer product.
But the scientific literature on whether that potential contamination translates into a real-world cancer risk for consumers is just maddeningly divided.
It really is.
I mean, the sources present two completely different realities. On one hand, we have the World Health Organization. In 2024, their International Agency for Research on Cancer, IIRC, officially reclassified talc from a possible cause of ovarian cancer to a probable cause.
Which is a major escalation from a global authority.
Right. And adding to that, a recent study published in the Journal of Clinical Oncology explicitly linked the application of genital talc to an increased risk of ovarian cancer.
But, to understand the weight of those findings, we have to look under the hood at how those studies are structured.
Okay, how so?
Well, many of the studies finding an association, which, by the way, often hovers around a 30% increased risk, they rely on an epidemiological method that looks backward in time. So researchers identify a cohort of women who already have ovarian cancer, and they ask them to detail their talcum powder use from 20 or 30 years ago.
Which introduces a huge variable.
Exactly. It's known as recall bias. Human memory is fallible. And when someone is dealing with a devastating diagnosis, there's a natural psychological drive to find a cause.
Right. You want answers.
You do. A patient searching for answers is statistically way more likely to over-report or fixate on their past use of a suspected product compared to a healthy control subject.
Okay, that makes total sense regarding the backward-looking data. But the sources also highlight an absolute heavyweight study on the other side of the debate that eliminates that bias entirely.
The JAMA study.
Yes.
Yeah.
The JAMA study published in the Journal of the American Medical Association tracked 250,000 women over the course of 11 years.
Because it's a forward-looking study, it doesn't rely on anyone's memory of, the 1990s.
Right, they track the data in real time.
Exactly. And the result, they found no statistically significant relationship between talc use and ovarian cancer. None.
And prospective longitudinal studies like the JAMA research are widely considered the gold standard in medical science,
Yes.
precisely because they eliminate that recall bias.
Professor Ian McNeish, he's the director of the Ovarian Cancer Action Research Center, he weighed in on this. He emphasized that definitively proving causation in human biology is incredibly difficult, but he categorized the JAMA study as highly robust.
Because of the sheer size of it.
Yes.
Yeah.
His underlying point is statistical. If talc were a primary aggressive driver of ovarian cancer, tracking 250,000 women over more than a decade should reveal a glaring, undeniable spike in the data.
Right.
The fact that it doesn't is just a formidable piece of evidence for the defense.
It is formidable until you read about the scandal involving the Lancet.
Oh, yeah. That casts a huge shadow over the defense's entire scientific narrative.
Right. The Lancet is one of the most prestigious medical journals in the world, and they recently retracted a highly influential 1977 paper that had been used for decades to establish the baseline safety of cosmetic talc.
It's a huge deal.
And the retraction happened because the author was revealed to be an undisclosed paid consultant for Johnson & Johnson. He even shared drafts of the research with the company prior to publication.
And the retraction of a foundational paper from 1977 matters immensely in 2026 because of how scientific precedent works.
Right.
That specific paper was a cornerstone. Defense attorneys literally held it up in courtrooms for decades to convince juries that the scientific consensus was settled.
So it poisons the well.
Exactly. When it's revealed that a foundational piece of the literature bypassed objective peer review due to a hidden corporate conflict of interest, it shatters public and judicial trust.
So even if modern, perfectly executed studies like the JAMA ones show no link, juries are fundamentally suspicious of the corporate narrative.
Yep.
I mean, for you, the everyday listener trying to navigate these sources, it is an impossible position.
It really is.
You have the WHO escalating warnings to probable carcinogen, a 250,000-person gold standard study showing no statistical link, and top medical journals retracting safety papers due to secret payouts. It's paralyzing.
Yeah.
Ultimately, the market essentially made the decision for us. Facing plummeting sales and unquantifiable litigation costs, J&J stopped selling talc-based baby powder in the U.S. and Canada in 2020.
And they discontinued it globally by 2023.
Right, replacing the mineral entirely with cornstarch.
Yeah.
So the product is gone from the shelves.
The product is gone, but the exposure has already occurred for millions of people over the span of a century.
Yeah.
The timeline of those past exposures is colliding with the present day, resulting in a legal pipeline of over 68,000 pending cases.
Which shifts this entire narrative from the science lab straight into the corporate boardroom.
Because managing 68,000 active lawsuits is an existential financial threat to any corporation.
Oh, absolutely. Wall Street abhors unquantifiable risk.
And 68,000 spins of the jury roulette wheel, where any spin could result in a $1.5 billion judgment. That's the definition of unquantifiable.
Yeah, it is.
So to survive, J&J has attempted a legal maneuver so bold it has infuriated lawmakers and plaintiffs alike. It's called the Texas two-step.
I look at the mechanics of this, and the best analogy I can think of is corporate mitosis.
Okay, I like that.
It's as if a healthy cell duplicates itself, genetically engineers the new cell to carry 100% of a fatal disease, and then immediately puts that new cell on life support in a bankruptcy ward so the original cell can walk away completely healthy.
That is actually a remarkably accurate description of the mechanism.
Right.
The Texas two-step exploits a specific provision in Texas corporate law known as a divisional merger. It allows a parent company to literally divide itself into two distinct entities.
Okay.
The parent company retains the valuable assets, the operational revenue, the intellectual property, but the newly created subsidiary is saddled with all of the toxic tort liabilities in this case, the tens of thousands of talc lawsuits.
Wow.
And the crucial second step is that immediately after the division, the newly burdened subsidiary files for Chapter 11 bankruptcy.
So they engineer a subsidiary whose sole purpose is to take the fall and die.
Essentially, yes.
They basically take all their money and put it in a steel vault, put all the lawsuits in a cardboard box, and set the cardboard box on fire in bankruptcy court.
Yeah, because the strategic goal of that bankruptcy filing is the automatic stay. The moment a company enters Chapter 11, The bankruptcy code immediately halts all civil litigation against it across the entire country.
So it freezes everything.
Exactly. The strategy is to stop 68,000 unpredictable jury trials in their tracks and force every single plaintiff into a single global settlement trust negotiated under the controlled environment of a bankruptcy judge.
And J&J has aggressively pursued this strategy.
Right.
The sources detail their third most recent attempt using a specially created subsidiary named Red River Talc.
Right.
And through Red River, they proposed an $8 to $9 billion settlement fund designed to resolve 99.75% of all pending and future claims over a 25-year period. But the maneuver collapsed.
It did.
In March 2025, U.S. bankruptcy judge Christopher Lopez threw the entire plan out. Why did it fail?
Well, Judge Lopez's ruling really dismantled the mechanics of the plan. Under Section 524G of the Bankruptcy Code, creating an asbestos trust requires a supermajority. You need a 75% approval vote from the actual claimants.
Okay.
J&J submitted the plan claiming they had achieved that threshold. However, Judge Lopez scrutinized the process and found severe voting irregularities.
Like what?
We're not just talking about minor clerical errors. He cited an unreasonably rushed voting timeline that prevented proper review. And more alarmingly, he found instances of lawyers casting blanket votes on behalf of clients without securing direct, informed authorization.
Yikes.
And even evidence of no votes being mysteriously converted to yes votes outside of established legal procedures.
So the foundation of the 75% approval was procedurally hollow from the start.
Exactly.
But there was also a larger structural issue he cited regarding who actually gets protected by this bankruptcy, right?
Yeah.
Tying back to a major Supreme Court precedent.
Yes, the structural flaw was the breadth of the legal shield. Judge Lopez noted the plan offered overbroad liability protections to more than 700 non-debtor entities affiliated with J&J.
Wow. 700?
Yeah. He ultimately ruled that the Red River Plan violated the core tenet of the Supreme Court's recent Purdue Pharma decision.
Okay, and what does that precedent say?
The mechanism established in the Purdue ruling is clear. You cannot use the bankruptcy courts to grant non-consensual releases of liability to third parties who have not actually filed for bankruptcy themselves.
Oh, I see.
Because the parent company, Johnson & Johnson, did not file for bankruptcy. Only the Red River subsidiary did Levitt. J&J cannot legally utilize the bankruptcy code to shield its own assets from the plaintiffs.
Okay, I understand the legal mechanics of the Purdue ruling.
Yeah.
And obviously the outrage over the voting irregularities. It looks terrible on paper.
It does.
But I want to push back on this purely from the perspective of the actual victims. Like, we just outlined how incredibly complex the science is.
Yeah.
We just saw a jury in Los Angeles give the families of 3 deceased women absolutely $0 after years of litigation. We know that the first year of treatment for ovarian cancer can cost upwards of $100,000.
Easily.
These families are drowning in medical debt right now. So isn't an $8 or $9 billion guaranteed trust fund where victims can actually access funds to pay for chemotherapy, isn't that functionally better for them than waiting 5 years for a trial they might lose?
You know, you are highlighting the most agonizing tension in modern mass tort law.
Yeah.
The immediate human reality is that a guaranteed settlement fund provides tangible relief to victims whose time and resources are running out. There's a reason many prominent plaintiffs' attorneys actually supported the Red River bankruptcy plan.
Right, because they want to help their clients now.
Exactly. They recognize the brutal arithmetic of the jury system, and their primary duty is to get their clients financial help before they succumb to the disease.
So why stop it? If the victims need the money and the company's offering $9 billion, why does the system block the exit?
Because the justice system has to weigh immediate relief against systemic, long-term corporate accountability.
Okay.
The bankruptcy code was designed as a mechanism to help genuinely distressed, insolvent companies reorganize their debts and pay creditors as fairly as possible with limited resources.
Right.
Johnson & Johnson is not distressed. It is a solvent, highly profitable corporation with a market capitalization in the hundreds of billions of dollars.
Yeah, they're not going under anytime soon.
Exactly. If the courts validate the Texas two-step, allowing a company of that wealth to unilaterally cap its liability, dictate the terms of its own settlement, and completely bypass the jury system, it upends the foundation of corporate liability.
It sets a dangerous precedent.
It establishes a legal precedent where the world's wealthiest corporations can simply purchase an off-ramp from the justice system whenever a product turns out to be dangerous.
That is the macro-level view that makes this deep dive so critical.
Yeah.
I mean, Why does the intricate mechanism of a divisional merger matter to you, listening to this right now? Why should you care about the difference between longitudinal data and recall bias?
Yeah, it matters.
It does, because this is not just a story about Johnson & Johnson or a bottle of baby powder. It's a profound case study in our modern reality. It exposes how agonizingly slow the scientific method moves when trying to establish definitive proof in a really complex world.
And it highlights how messy and unpredictable our legal system is when tasked with establishing truth in the absence of that scientific certainty.
Yeah.
The overriding takeaway from these sources is really a lesson in the limits of certainty.
Yeah.
The interconnected systems we rely on to navigate the world and protect ourselves, corporate ethics boards, regulatory agencies, scientific peer review, and the courts, they're entirely comprised of flawed human institutions.
Absolutely.
They're susceptible to bias, vulnerable to manipulation, and frequently gridlocked by honest, irreconcilable disagreement.
Which leaves a final, deeply unsettling thought to ponder long after we wrap up today. If a product as benign, as simple, and as universally trusted as baby powder can become the epicenter of a $9 billion legal war simply because of the microscopic dust it happens to sit next to in the earth, what other daily habits or seemingly innocent products sitting in your home right now are currently resting on a statistical knife edge of safety, just waiting for the science to catch up? If you found this episode valuable, please like, subscribe, share, follow, and turn on notifications. It helps us continue bringing you content like this and ensures you never miss future releases.